Emalahleni, is that it?
eMalahleni.
Yes. And which degrees do you have?
I hold a B.Proc from the University of Limpopo now, and an LLB. I also have,
Is the LLB also from the University of
it's also
Limpopo?
from the University of Limpopo.
Was it still Limpopo or was it Terflup then?
It was Teflon,
Yes.
University of the North.
You also?
And then I also have a certificate of in international international commercial law, and I have a diploma of in administration of insolvent estate from Pretoria University.
Yes.
The certificate in corporate law is, or corporate international law, is from Freie University in Amsterdam.
Yes. Take us through your employment history that is relevant to the practice of the law.
I started working at Concilium Legis in Pretoria. It was a consulting firm, and I was a legal researcher there. And I then, that was in 2000.
Did they focus on certain areas of the law? Were they general practitioners, so to speak?
It was general practitioners, but they focused also more on legislation and policies of the road Department of Roads.
Yes.
Yeah,
Thereafter?
or transport.
Okay, yes.
Then I served my articles in Polokwane at Manko and Makgabane attorneys in 2001. And then in 2002, I was admitted as an attorney, and I served as a PA at Manko and Makgabane attorneys. Then I proceeded to, in 2003, I then established a law firm, and under the name Mahosi Incorporated. And I was also then appointed to be a lecturer at the University of Limpopo at that time. I have been...
What were you offering?
I offered labor law, mercantile law, and also law of succession, if I'm not mistaken.
Yes. And so you have been an attorney for how long?
I have been an attorney for 15 years now.
15.
Yes.
Have you acted at the labor court?
I have acted at the labor court. I started acting at the labor court 2016 in January. I acted for a full term, and I acted also in the third term, and also in the first term of 2017, this year.
Was it an intimidating atmosphere or a welcoming environment?
The environment was welcoming, but when I started, it was, I must say that it was intimidating at the beginning, but after 2 weeks or 3 weeks or so, I became a bit comfortable, and I was able to.
Didn't you find judgment writing to be a serious challenge?
Judgment writing was not necessarily a challenge that much. I think what was challenging, or what I found to have done, which actually perhaps worked against me, was to try and be too thorough and perfect, and I ended up over-analyzing, which resulted in me giving longer judgments, and that also affected my turnaround time of handing down judgments.
On average, what is your turnaround time?
At the beginning, a number of them were within 3 months, but I have judgments which were delivered 6 months later. And as I said earlier, it was due to me trying to be perfect, and in trying to find a style of writing, I would overanalyze and write longer judgments. And that, of course, resulted in me delivering those judgments a bit late. And I must say that it was not good for the parties, and I must apologize for that from the beginning. Yes.
It's something you regret.
Yeah.
Ideally, within which period would you want to be able to hand down a judgment from the time it is reserved?
Ideally, it should be before 3 months. In fact, maybe the second month. That is if I've reserved it for
Yes.
longer.
Yes.
But being at the labor court, labor matters in themselves are urgent matters.
Yes.
And judgments should actually be delivered within a very short space of time.
Yes. Did you find some support from permanent members of the court? Or were they just too busy to find enough time for you, to avail enough time to you?
Permanent members at the labor court, I find them to be always available to assist, especially to listen and just to give that support. But as a judge, you still have to sit, and it's actually a decision that you have to make on your own independently.
Yes. Thank you. Acting Judge President Laleti.
Thank you, Chief Justice. Good morning, Acting Judge, at the moment.
Good morning.
Good morning. You are acting at the moment.
I am not acting at the moment. I'm going to be acting at the beginning of the term.
Yeah, which means your acting stint for this year has been extended for another term.
For another term, yes.
Yes. Right. At the Labor Court, we've got 3 divisions: the motion court, the trial court, and agent court.
Yes.
Yeah. I just want to take you through during your acting stints. Like in 2016, you acted from the 24th of January, and then it ended on the 1st of April 2016. You remember?
Yes.
Yeah. And then you did, according to the statistics that we have, you did 3 weeks of motion court during that stint.
Yes.
And then the trial court, you did 6 weeks.
Yes.
And then the agent court, you did 1 week
I
of
did
agent.
1 week of it.
Right. And then the stint that you were in, the 25th of July to the 26th of August, which was a very short stint, you did 2 weeks of motion court
Yes.
and 2 weeks of trial court,
Yes.
and then you did not do the agent court at the
I did
time.
not do the agent court at
Yes.
the time.
And then this year, the 2017, from the 30th of January up to the 24th of February, you did 2 motion court, one in Johannesburg and the other one in Port Elizabeth.
Yes,
And then you also did a trial court, you had 2 weeks,
that's correct.
and you haven't done agent court yet.
I haven't done an agent court
Yes.
this time.
Of the 3 divisions, which one do you find more challenging, time-consuming?
The motion is more challenging because that's where you actually pick up a lot of reserved judgments. But what I've realized is that when I'm able to give extempore judgments, then in that way, I do not reserve a lot of judgments. And I've realized that it actually is possible to do that.
I see. Okay. And then you know that the Labour Court is a national court, it's got national jurisdiction, there's a lot of traveling.
Yes.
Would you have any problem in traveling, since at the moment you've got satellite courts in Durban, Port Elizabeth, Cape Town, and then it also sits at other cities depending on the number of cases we've got in those cities like Polokwane, Bloemfontein and Kimberley. Would that be any problem to you traveling?
It is not a problem. It has not been a problem. In fact, I have, as you indicated earlier, I have been to PE, and I also have been to Cape Town. So I'm always happy to assist in all other offices of the Labour Court.
I see. And then in your questionnaire, under section 2, where it relates to the legal background, I would want you to have it in front of you there.
Yes.
Yes. It will be under paragraph C. Right at the end, you say that I am currently still resident in Johannesburg and run a small practice more on consultancy basis. Would you just maybe explain that? What does that imply?
Yes, what that means is that my practice focuses more, in fact, what I am doing mostly, I must indicate that I'm a part-time commissioner at the CCMA and the bargaining councils. So what I do mostly is labor matters, where I would, if I'm not at the CCMA or bargaining councils, then I would be assisting with the disciplinary hearings and matters relating to labor. As such, my practice is not more on litigation per se. At the moment now, at the moment.
I see. Well, that takes me to paragraph 6.3, where you refer to cases where you have appeared. Are these the cases that you have appeared in court, or what is the situation? You don't indicate in the form.
Those are the cases where I have appeared in court and also at the CCMA. That was before I was a commissioner at the CCMA.
I see. And then just one aspect that I want to clear up with you. On the comments from the law bodies, there's one from SASLO, of which you are a member, is it?
Yes.
Yes. They make a comment. Unfortunately, we do not know who's making this comment, but apparently they circulated names among their members and then they make comments. There is a mention that you postpone cases or a case only because the parties failed to file a practice directive. Would you want perhaps to share some light on that?
Okay. I remember that matter very well because it was not long ago. What had happened there is that parties appeared, and when they appeared, I then realized that there was no practice note in their file. And when I asked them to address me on that, they could not give a proper explanation. In fact, what the council said was that he requested that I should stand the matter down. For the purpose of him, he actually wanted to take instructions from his attorney. Then he indicated that his attorney was actually on his way to court. And when the attorney came, they could not explain why their papers or the practice note was not in the file. They actually even did not request the court to indulge them in that matter. And what then happened was the respondent then, in his address, indicated that in that case, it would then mean that I had not, I did not appreciate the matter, because you see also, the thing about the purpose of the practice note is for the judge to be able to know what the matter is all about. So when you don't have papers that are in order, you are not put in a position for you to be able to appreciate exactly what the matter is all about. So in terms of the practice manual, when the practice note is not in the file, the only way to deal with the matter is to remove the matter from the roll, unless the parties are able to give you a proper explanation.
Now, my last question, I know the Chief Justice has already asked you about this. It's regarding collegiality at the Labor Court. How did you find it? Did you find them accommodating to colleagues who are coming to act, particularly women colleagues who are acting? And I'm not buying your face. If there are problems, it will be important for us to know those problems so that we can attend to them. The aim is to make that place as friendly as possible.
I find members to be, or permanent judges to be very accommodative and very supportive, and the treatment that I got there as an acting judge was it was not it was very welcoming, in fact.
I see. Thank you, Chief Justice.
Thank you, Acting Judge President. Mr. Njalinjali.
Thank you, JC. I have three questions to raise with yourself, if you don't mind. The first one is that in your history of employment, you have been a commissioner, accredited, I would assume, by the system.
I'm sorry, Mr. Njalinjali, if you could have the mic closer to you so we can hear you well.
Thank you very much. You indicate that you have been a commissioner for various bargaining council, including the CCMA. I assume that you have been accredited by the CCMA, is that correct?
That is correct.
What level were you in terms of levels? Normally level B, level A, senior commissioner.
I'm a
What
level B commissioner.
Level B commissioner. Yes. One of the strict requirement in the CCMA to continue to be commissioner is based on the judgment, the submission of judgments, delivering of judgments or awards, let me put this, awards. Yes. What has been your average? Are there any late judgments that you have been doing, if any?
I have not delivered awards late at the CCMA and the bargaining councils. My awards were always
on time.
On time.
Thank you very much. On the question then, on the one in your acting, you indicated that there's been a challenge in relations to judgments. You said the impact of being perfect have led to late judgments. Did I heard you correct that you were trying to be perfect? As a result, you spend more time in terms of writing these judgments. I didn't hear you as to how do you intend to address that one?
I have actually learned from my experience, and as a result, I have adopted, or I'm trying to adopt a style of writing shorter judgments without compromising the quality. And I can say that from the period that I've acted in the first term, to date, I do not have any reserved judgment at all.
That's good. But taking into account, is my last question, JC, considering the time that you have being acting and the fact that in terms of the 3 divisions that the acting JP was talking about, you have only spent 1 week, if it's calculated by weeks, if I'm not mistaken, on the agent one. And I had you comparing the two. You seems to say the motion one is the more that you must apply your mind quickly. Is it not the opposite, that one? On the agent one, that's when you have to act decisively and be able to indicate the judgment.
It is correct. What I was saying was that as much as there are urgent matters that come before the Labour Court, all matters that actually come before the Labour Court are urgent in their nature. I do agree that on urgent role, the judgments would have to be delivered urgently. And I have, when I acted or when I was on that role, I was able to deliver my judgments within an acceptable time.
Thank you, JP.
Thank you very much, Mr. Njali. Acting President Maya.
Thank you, Chief Justice. Good morning, Ms. Mahosi.
Good morning, ma'am.
I must say you have quite an impressive CV, and I thoroughly enjoyed reading the judgments that are attached to your questionnaire. You write well, so I don't think you have anything to worry about on that score.
Thank you, Commissioner.
I just wanted to ask you one thing. It has been found that a number of women graduate from our law schools, then they go to serve their articles of clerkship and do pupillage, and they succeed, and then they go into the professions but don't stay. Now, I ask you this because I noticed that after you completed your articles, you went into practice, but you stayed only for 1 year. And I just wanted to find out why you left. You went to teach, I think?
I did not leave. What had happened was, after serving my articles, I stayed as a PA at the same law firm. Then I established my own law firm from 2003. But at that time also, I was appointed also as a lecturer at the University of Limpopo. So I have been practicing from 2003 to date.
Oh, I'm sorry, I misread your form. I thought you went to teach, then came back to start your own practice.
No.
So you were both
Yes,
teaching
I was-
and practicing at the same time?
I was both practicing and teaching at the same time, and I was also an instructor at the practical legal training.
And a
school.
mother as well.
And a mother, and yeah. And I was, at the time, of course, I was starting a family, so you will realize that it was not an easy road, but
And how were you able to juggle all those roles?
it's not an easy balance, but you try and do what you're supposed to do.
I know I said I was going to ask you one thing, I just noticed something else. In your questionnaire, you record that you have outstanding judgments reserved in August last year.
Yes.
Have you been able to finalize them?
Yes, they were all finalized. As I indicated earlier to the Commissioner, I have no reserved judgments at the moment.
Thank you very much.
Thank you.
You have come up to this level. What advice would you give a young woman who wants to work her way up to the High Court, Labor Court, and so on? How were you able to find your way through the many barriers that women have to contend with during practice until, if they are able to, until they reach High Court or Specialist Court level? How did you survive? Because many don't.
What is important is to keep your eye on the ball and to persevere, and also to get support from colleagues. not only from colleagues and also from the family and from your friends. It's hardworking and hardworking all the time.
Thank you. Commissioner Msomi?
Thanks, Chief Justice. Good morning, should I say, Ms. Mahosi? Ms.
Good morning, Commissioner.
Yes. I just want to refer you to this book, which is titled Labor Court 2 Vacancies, Feedback from Law Bodies.
Yes.
In particular, I would like to refer you to the results of what appears to have been a survey done by the South African Society for Labor Law. Have you been able to
Saslo, yes.
pick that up?
Yes,
Are you a member of SASLO?
I am a member of Saslo. What had happened is that I only joined Saslo late last year. It was at the time when I was actually acting
Okay.
at the Labour Court.
And I just wanted to get your response to the results of that survey. You appear to have scored the lowest in terms of the responses from the members of that body regarding your suitability for appointment. Do you see that? You scored 14%. Is it 14? Or 20.3%?
For 20 pen, yes.
20.3.
Yes, I can see that.
What is your response to that? Were these people fair to you? Unfair to you? And why?
Most of the comments that came up from this body indicates that I am not known,
Yes.
and it is understandable because most of my years or the years that I've spent in practice, I was actually in Limpopo and not in Gauteng. So I am fairly new in Gauteng.
Okay. If I were to ask, if you were to quantify your time as an acting judge in the Labour Court, in totality, how much time have you spent? 2 weeks there, a month there, but in totality, as an acting judge, how much time have you spent as an acting judge?
If I'm not mistaken, it should be 5 months,
It is 5 months. Having spent
or just over 5 months.
just over 5 months. In all fairness, do you think that period has prepared you well enough now to get a permanent appointment? If so, why?
It has prepared me well enough. What has also not, it's not only that period that has prepared me for the appointment, but also my experience as an attorney, the time that I spent at the CCMA as a part-time commissioner also has prepared me.
Are you familiar with the norms and standards that govern judges in this country? And what do they say about the length of time that it must be taken to deliver judgments?
Judgments must be delivered as soon as possible, but it should not also be beyond 3 months.
Is there not a recommendation there of a 3-month period from the date the matter is finally heard?
Yes, it is exactly that.
It will appear from the responses that have been raised by various bodies that one of the issues that they take with you is that you take longer to deliver your judgments. Now, in labor law, as you may be aware, lives of people are dependent on it. Someone has been fired, they are unemployed, or it's an employer who could be wanting to replace a dismissed employee. They can't finalize the matter because judgment is still outstanding. Do you appreciate the seriousness of not handing down judgment on time on the broader economy?
Commissioner, she explained it earlier. She explained it earlier, unless there is an aspect of answer that you want to clarify. She did explain, respond to that earlier, but it may well be that you want to clarify that, her answer.
Okay, for my benefit, Ms. Mahosa, could you please clarify that? Mahosi. I'm sorry, Commissioner Madema. Mahosi. Are you able to clarify that for me? I did not get the clarity.
I do appreciate the importance, as I indicated earlier. I did say that as much as there's an urgent court at the Labour Court, my view is that all matters that go to the Labour Court are urgent in their very nature, and judgments thereof should be delivered as soon as possible.
Thank you so much, Chief Justice.
Thank you very much, Commissioner Msomi. And you actually volunteered that information, isn't it?
I have.
In the course of dealing with the judgments that were reserved for a long time, which you expressed regret for.
Yes, I did.
Yes. Professor Ntlama?
Thank you, CJ. Morning, Ms. Mahosi.
Good morning, Commissioner.
Just two questions. I'm excited when I saw someone from the academia. Can you please share with us your experience as an academic as to how it has prepared you or contributed to your ability to become a judge?
Yes, being an academic involves researching the law. And that is actually a skill that is very important to all judges, being able to find the law and to be able to apply it.
Then how does that assist you in the advancement of your judicial career?
As I indicated earlier, being in academia, it doesn't only involve teaching or lecturing, but also you have to be a reader. You have to read a lot. You have to be able to analyze the law and apply it, and that knowledge is very helpful and preparing one to be a judge.
Then, as a woman, other than your technical expertise, what do you bring to the judiciary?
I bring compassion. I bring the love of the law. I bring understanding, patience, and being able to listen, which is a very, I believe it's a very important skill to have if you are to be a judge. Thank you.
Thank you, Commissioner Ntlama. Commissioner Norman?
Thank you, President Maya. Good morning.
Good morning.
Ms. Mahosi. Sorry. Oh, thank you. Well, for me, I think my questions have been taken care of, but what I wanted to just draw to your attention is that it seems that the Saslo, the complaint was that the whole issue about the practice note, you did not deal with it in chambers. You could have dealt with it in chambers before going into court. what is your response to dealing with matters in chambers instead of you dealing with them in court?
My experience is that it's always, as much as there are issues that you would raise with the parties in chambers, it's always better to deal with matters on record in court, and that way you have record of exactly what you have said. And you don't run a risk of parties complaining about your conduct in chambers where there's actually no record.
Yes, thank you. And then the second thing is the same body that you are a member of says, for example, in their comment, Mahosi is a relatively unknown quantity. I mean, you know, what is that?
I have explained that earlier, that I can understand it because I practice mostly in Limpopo, in Polokwane, and I am failing you in Joburg. So I would not, for that member to have expressed that view, it would be understanding because.
Yes, but for me, I mean, isn't that derogatory? Because they are not simply saying that we do not know this member, but they refer to you as a quantity. I don't know what that means, you know?
It is derogatory.
Thank you very much. Thank you, Chief Justice.
Thank you, Commissioner Norman. Commissioner Nkosi Thomas.
Chief Justice, thank you. I will pass. My issues have been taken care of.
Thank you very much. Thank you very much, ma'am. You are now excused.
Thank you so much, and I'd like to thank you for giving me the opportunity to appear before you. Thank you.
Thank you.